These corrupt cops are trying to hide their dirty past from the jury. In the lawsuit brought by college student Tayvin Galanakis against the city of Fig Newton, Iowa, and several police officers, the defendants have filed a motion to bifurcate the proceedings. Now, I know that sounds complicated. In fact, it sounds bifurcated, and that's why I'm here. I'm America's attorney. I've been a lawyer for 24 years. I've helped over 12 million very happy people. Let's break down the latest motion filed in the Tayvin Galanakis false DUI arrest case. If you like your legal analysis accurate, your court filings actually read, and your police misconduct coverage free of vibes and guesswork, hit subscribe. I read the motion so you don't have to. I translate lawyer nonsense like bifurcate into plain English. And I'm not here to both sides things that are clearly ridiculous. New cases, real documents, zero fluff, and even less hair. Subscribe so you don't miss the next filing that somehow makes things worse for everyone involved. As this case heads towards trial, the core dispute is simple but dramatic. A young man with a 000 breathalyzer reading was handcuffed and charged with operating while intoxicated, and now he's suing under federal civil rights law. In Galanakis versus City of Fig Newton, you know what? If you Google that, take the fig out. Trust me, you get better results.
Where am I?
19-year-old Tayvin Galanakis alleges that officers Nathan Winters and Christopher Wing lacked any lawful basis, no probable cause, to arrest him during a traffic stop in August of 2022 after he was stopped for driving with his high beams on, repeatedly denied drinking or using drugs, and even agreed to a drug evaluation that showed no impairment. Courts have already allowed his Section 1983 unlawful arrest and Iowa false arrest claims to move forward, and a federal appeals panel has rejected the officer's claim to qualified immunity, concluding that no reasonable officer could think that there was a substantial chance that Galanakis was impaired given his behavior and test results. At the same time, the officers have filed their own counterclaims against Galanakis, alleging defamation and invasion of privacy based on statements he posted online about the encounter, though many of those have been pared back by earlier rulings. And I'd just like to say to all the dirty cops out there, if you're watching the channel, if you want to make sure that everyone knows that you are a dirty cop, you should definitely sue the people that you illegally arrested. Like, it makes it crystal clear that you are what we think you are. And a little bit of housekeeping. I keep referring to Tayvin Galanakis as 19 years old, which he was in 2022. But my guy's about to graduate from college, and he's either 22 or 23, and he's not a kid anymore. And hopefully, he graduates from college and has like the down payment for a house or something from the outcome of this case. That's my hope. Anyways, just 1 week ago, the defendants in Galanakis versus City of Fig Newton filed a motion to bifurcate the trial, asking the judge to split this case into two separate proceedings under Federal Rule of Civil Procedure 42B. That's the rule that gives federal courts broad discretion to order separate trials for convenience, to avoid prejudice, or to expedite and economize. They want Trial 1 to cover Tayvin's wrongful arrest and false arrest claims, and Trial 2, a completely separate proceeding in front of a different group of jurors, to cover Winters' defamation counterclaim. The defense argues that trying all these issues together could unfairly prejudice the jury or introduce evidence and issues that don't logically belong together, and that separating them will streamline the process and reduce confusion over what the jury is being asked to decide. In other words, they're worried that the jury will learn that the arresting officer pled the fifth when asked about beating his girlfriend, and the jury might think, hey, maybe this guy isn't credible. Maybe this guy makes bad decisions. Maybe this guy shouldn't be believed when he says he had probable cause. Just sit with this for a second. The key witness in the arrest is Officer Nathan Winters. And when Tayvin's lawyers asked him during his deposition if he had ever assaulted a girlfriend, he pled the fifth. It just makes me feel crazy.
Stop it. Get some help.
Everyone has an understanding of what it means to plead the fifth. Like, if you're a defendant in a criminal case, you have no obligation to incriminate yourself during an interrogation or on a witness stand, and refusing to testify can't be used against you. But Officer Nathan Winters was not a defendant in a criminal case when he pled the fifth. He was merely a party to a civil lawsuit. And while it is legal for him to plead the fifth, since this was not in a criminal case and he was not a criminal defendant, pleading the fifth does not protect him from having the jury be instructed by the judge that they may assume that the very reason that he pled the fifth is that he actually did do the bad deed, aka commit the crime, aka beat his girlfriend, just as the questions suggested and just as he refused to answer. This is a critical distinction between civil cases and criminal cases when it comes to pleading the fifth. Whew, okay, I was really feeling that. I was was worked up. At the heart of their motion, they say, is their concern that evidence relevant to the officer's counterclaims, which focuses on statements Galanakis made after the traffic stop, could bleed into the jury's evaluation of whether the initial arrest was lawful. Federal courts routinely consider whether trying tangential issues together will risk prejudice or confusion, and defendants here contend that combining the constitutional arrest claims with post-incident speech disputes would do exactly that. But that's not prejudice. That's relevant character evidence. That's credibility. It's also context. It's the whole story. That's the jury doing exactly what the jury is supposed to be doing. By separating the trials, the defense believes that the court can ensure that jurors assess each claim on its own legal and factual footing without conflating issues that serve different purposes and standards of proof. In other words, Winters' lawyers are concerned that the jury is going to hate Winters. But why? Now, to be fair, bifurcation motions aren't inherently bad. Sometimes they make sense. If you have genuinely unrelated claims with no evidentiary overlap, splitting them can simplify things. And I'll even give you an example. Let me say I sue you for breach of contract in a totally unrelated thing. You and I have a car wreck and you sue me for a car wreck. Well, those are totally different cases. And courts applying Rule 42B have broad discretion to craft the shape of a trial, from splitting liability and damages to isolating defenses or counterclaims. But bifurcation is traditionally the exception rather than the rule, granted only when the court believes that the benefits of separation outweigh the costs of holding multiple proceedings. Because trials are disruptive, like for the jurors, for the judge, for the lawyers. They take a lot of time. That means that the judge in this case will weigh whether keeping Galanakis' Fourth Amendment arrest claim and the officer's speech-related counterclaims in one trial would actually risk prejudice or confusion that Rule 42 is designed to prevent, or whether a split would better serve fairness and judicial efficiency. But here's what this motion tells me as a lawyer. The defendants are scared. They know that if a jury hears the full story, the arrest, the breathalyzer, the convenient pivot to marijuana, the defamation counterclaim, the Fifth Amendment invocation, they are in trouble. A unified trial lets the jury see the complete picture. A bifurcated trial lets the lawyers for the dirty cops sanitize it. Show the jury a clean version of Winters in trial one and hope they find for the defense. And then deal with the defamation claims later with a different jury, maybe with a settlement, and maybe just dismisses those claims because they are. In responding to the defendant's motion to bifurcate, Galanakis' camp is almost certain to argue that splitting the trial isn't necessary and would ultimately penalize him, not serve efficiency or fairness, and would likely emphasize that all the claims, both his Fourth Amendment unlawful arrest and the officer's defamation and invasion of privacy counterclaims, arise from the same underlying sequence of events, namely the traffic stop, the arrest, and his subsequent decision to publish body cam footage online. He might also mention that Winters filed his defamation claims as a counterclaim to this case, suggesting that Winters believed that these claims were related. Courts generally prefer to keep related claims together when they involve overlapping evidence and context, and forcing separate proceedings that could drive up costs, delay resolution, and risk inconsistent outcomes if two juries hear competing narratives about the same core facts. Galanakis also might stress that judges can mitigate potential prejudice simply through limiting instructions that tell jurors what evidence they may consider for which issues. And the ball will soon be in the court's hands. The judge will review the written briefs from both sides, consider arguments at a hearing if one is scheduled, although that's kind of unusual for motions like this in federal cases, and then just decide whether splitting the case into separate trials makes sense. A ruling in favor of bifurcation could narrow the focus of jurors in each trial and exclude certain testimony in the first phase, whereas a denial would keep all claims before a single jury for better or for worse. Until death do them part? Whatever. Whether the judge grants the motion or not, the outcome shows how courts balance complex constitutional claims and overlapping counterclaims in high-profile civil rights cases, underscoring that how a case is tried can be just as impactful as what the verdict ultimately is. Hey, what are your thoughts on the officer's motion to bifurcate? Do you think it's fair play or a ploy to try and sway the verdict because Winters is guilty? Oh, drop your pro se opinion down below and let me know what you think. And don't forget, while you're down there, to lawyer up with me, America's Attorney, by hitting the subscribe button so that you can find out what arguments, if any, Galanakis' team makes and how the judge ultimately rules. I promise you, I will be back soon with more legal breakdowns, and I hope to see you then. You can go now. Bye-bye. In front of a completely separate jury. Whoops. But Galanakis might also stress that judges can mitigate